If you're a lawyer and you're from out of state and you're thinking about handling your client's cruise ship accident case against one of the major cruise lines, think twice before you do it. If you're going to handle a case like this, you should contact one of the lawyers, there's only a handful of them, who routinely sue the cruise lines. There's a couple of things that you need to know before you could even consider taking these cases on. The first is you need to know what your client's ticket contract says. Your client probably doesn't even know that they agreed to a ticket contract. But every passenger who goes on a cruise ship agrees to the terms of the ticket contract, and those are published online on the cruise ship's website. The first and most important thing you need to know is the forum for where your client's lawsuit must be filed. Usually against many of the major cruise lines, Royal Caribbean, Carnival, Norwegian, your client's case will have to be filed in federal court in Miami, Florida, the United States District Court for the Southern District of Florida. You have to file that lawsuit in less than 1 year from the date of your client's accident. If you do not do that, your case will be barred forever. So if that's not enough to scare you away from doing these kind of cases on your own, there's more. The second thing you have to know about just from the ticket contract alone is that you have to put the cruise line on written notice of the claim with, quote, full particulars within 6 months of the accident. There are some ways around it if your client reported the incident on the cruise ship, filled out some forms that the cruise line gave to them at the ship's medical facility. But if your client didn't tell the cruise ship and the cruise ship had no knowledge about the incident and they didn't investigate, you better get your notice out there and comply with the terms of the ticket contract, which expressly state how the notice must be sent, when it must be sent, where it must be sent. After you get past the ticket contract, now you've filed your case in the United States District Court for the Southern District of Florida. You need to know how it works here. There's a pleading standard that you have to comply with. You have to plead specific facts for what happened. If your client has a slip and fall, for example, you have to plead prior incidents, not just, oh, we think maybe prior incidents happened. You have to be prepared to identify who had a prior slip and fall, where the slip and fall was, when the slip and fall was, and basically in your complaint, you have to prove that this prior incident is substantially similar or it may get disregarded. You might get 3 to sometimes 6 months to complete all of your discovery. That's not a lot of time. I've handled a case where my client was paralyzed. We alleged it was a medical malpractice by the cruise line, and we had to take depositions all over the world in that 6-month period. So we took depositions of witnesses in South Africa, the Philippines, several witnesses in Canada, Puerto Rico. We had witnesses in Atlanta, Miami. If you're going to take on one of these cases, you need to be ready to travel. You need to be ready to commit your practice to handling this case, because if it's a big case, it's going to take up almost all of your time. You need to know who to depose, what documents to ask for, when to ask for them, and how to take the depositions of these crew members who are traveling all over the world. So the moral of the story here is don't go it alone. We're always here to talk if you have any questions or you want to run your case by us. Not every case is going to be one that we would take, but certainly we could try to connect you with someone who might be able to help you and knows what they're doing enough so that you and your client are going to benefit from their experience.